Hi, welcome everyone. We'll just get started in a minute with our housekeeping. Thank you so much for joining us today. My name is Claire Ladd, and I'm the Programs and Services Manager at the Massachusetts Nonprofit Network, MNN. And just a few quick notes before we dig into the content. The recording and slides from today's program will be emailed to you following the webinar, so please keep an eye on your email for that in the next day or two. And during the webinar, if you have any questions for the presenters, please submit them via the Q&A function, and there will be allotted time to answer questions during the webinar. If you have any logistical questions or things for me about MNN, feel free to drop those in the chat and I will respond. I also just want to give a little background about us here at MNN. Our three goals are to strengthen the nonprofit sector through advocacy, public awareness, and capacity building services. And we offer regular webinars as part of our capacity building efforts in partnership with our affiliate members. So please stay tuned for any future topics in the coming weeks and reach out to us if there are topics you'd like to see in the future. Our efforts are made possible by our more than 600 member organizations. So to those of you who are members, thank you so much for your partnership. And if you have not yet joined the network, but would like to take advantage of the member benefits, such as networking opportunities and cost savings, please visit massnonprofitnet.org/join to find out more. Today's webinar is titled Nonprofit Provided Employee Housing: Can Nonprofits Build the New Company Towns? And it's presented by Katherine Garrahan, Peter Martin, Raymond Ripple, and Samantha McDonald of Bowditch. I will hand it over to our presenters to get started.
Thanks very much, Claire. As said, I'm Peter Martin. I'm an attorney at Bowditch in our Worcester office. And I just wanted to thank MNN for giving us the opportunity to talk with you this morning about this topic, which is an important one. We all understand as nonprofits that we're trying to attract and retain talented people in a very high cost region of the country. For many nonprofits, their employees are the biggest cost that they bear and a very important part of how they can possibly operate to provide services to the public. So that effort of recruiting and retaining employees has a lot of aspects to it, not just money, but things like benefits, tuition reimbursement plans, and the like, flexible schedules and that sort of thing. It is as applied to the nonprofit sector, there are some complications to this. You're not just ordinary employers, but you are employers whose mission is to serve the public and not the private interests of particular individuals, including your employees. And the effort to respond to sort of the housing crisis or the housing cost crisis in Massachusetts by nonprofits has resulted in a couple of recent examples. Probably the best known of these is the Martha's Vineyard Hospital effort that was announced in June of this year to provide housing. In that case, they provided 46 units of employee housing. Now, interestingly, that project also included 70 skilled nursing facility rooms. And the staff that are to be accommodated in the 46 employee housing units are to be chosen by lottery operated by the Dukes County Regional Housing Authority. And in the healthcare sector also, it's not uncommon for hospitals that have teaching programs to acquire properties on the periphery of the hospital and then make those houses available to, for example, medical residents and provide housing in partially in lieu of salary to those folks. So it's a live issue and it's a lot of complications involved with it. I am conscious of the fact that we are the only thing standing between you and the lunch hour. But I'm happy to tell you that I'm not the only cook in this kitchen. Ray Ripple in our Boston office is going to get into the meat and potatoes of employment law aspects of this type of benefit provision. And then Kathy Garrahan in our Framingham office will give you the straight cheese on zoning and Dover Amendment issues that are implicated. And finally, Sam McDonald of our Worcester office will offer some sweet talk on real estate tax exemption issues. And my task is to start you off by making you eat vegetables before you get to the yummier parts of the menu, and that those vegetables will take the form of some remarks about the tax law of tax exempt organizations. And in my presentation, I'm going to talk about three main topics. One, private inurement. Two, private benefit. And three, excess benefit transactions. And as is, I'm afraid, usual with lawyers giving webinars, there's a lot more guidelines and provision of language and grammar to help you deal with the issue rather than specific questions. Naturally, the specific issues that you will face in this area really depend on the particular facts and circumstances as we go ahead. So let's start then with private inurement. The basic tax law is that tax-exempt organizations have to be operated and organized exclusively for exempt purposes. Like a lot of language in the tax law, the word exclusively is not to be taken literally. Obviously, an organization has employees, and when it employs these folks to provide the charitable activities, those individuals are going to benefit. The private inurement doctrine is a very specific doctrine tied to benefits provided by tax-exempt organizations to what are referred to sometimes as insiders, officers, directors, founders, significant or substantial contributors, and key employees. The rules in the tax code define the key employees as the CEO, the COO, the CFO, but also persons with managerial control over a discrete segment of the organization. So it's a category of people that is not necessarily easy to define. But the key is to identify people in a position to exercise substantial influence over the affairs of the organization. There is a cutout for this. If an employee doesn't fall into any of these specific categories of insiders, that person is deemed not to have such influence over the affairs of the organization if the employee is not considered to be a highly compensated employee. And for 2025, the threshold for whether or not you're a highly compensated employee is $160,000. Okay, turning now to what constitutes inurement. It's important to say, as I just mentioned, private inurement is not a problem unless it represents unreasonable compensation, essentially above fair market value compensation. There are other types of private inurement that sometimes tax-exempt organizations get into trouble with. The interest-free or unsecured loans reminds me of the notorious case of the Stevens Institute of Technology in New Jersey, which provided its CEO a very low interest loan to enable him to purchase a vacation home in Vermont, and this loan was then forgiven. That is a stark and gross example of private inurement. Note here, please, that any amount of private inurement can result in a loss of tax-exempt status, but the question with respect to private inurement is whether or not the compensation or the transaction with the insider is considered reasonable. And this relates to our topic today because the value of housing provided to employees would be considered compensation with exceptions that we'll get into later. And so it's the unreasonableness of the total compensation, salary, benefits, housing, that will be evaluated. We'll talk a little bit later about how the Internal Revenue Code helps people determine reasonableness. These are called the intermediate sanction rules, which provide the wonderful doctrine of the rebuttable presumption of reasonableness. We'll talk about that later. So now let's turn to private benefit. Private benefit is a broader category, and it basically subsumes the private inurement doctrine, because the private benefit doctrine talks about not just benefits to corporate insiders, but to anybody who's not part of the charitable class that is to be benefited by the tax-exempt organization. And the analysis of private benefit differs from private inurement. Private inurement is a reasonableness determination. Private benefit is a question of whether or not the benefit is incidental. For example, the hospital staff receiving housing from Martha's Vineyard Hospital, probably a lot of those folks are not to be considered highly compensated individuals or corporate insiders, but they're getting a benefit, and they are not a part of the general patient population served by the hospital. So it's a broader category. And as I said, the question is whether or not the benefit is considered, as the IRS says, quantitatively and qualitatively incidental. So what does that mean? Qualitatively incidental means that the benefit is a necessary byproduct of the activity that benefits the public at large. You couldn't provide the public benefit without providing the private benefit. And quantitatively means it's basically a comparison between the value and extent of the private benefit in relation to the public benefit that the organization provides. There's no fast and easy rule here, but there are some factors that you should consider whether or not to evaluate whether or not a private benefit is incidental. So clearly, benefiting pre-selected individuals, one of the qualitative factors is if you were to benefit pre-selected individuals, that would clearly be a focus on the private people rather than the indefinite class of charitable beneficiaries. Presumably, this is why in the Martha's Vineyard Hospital case, the staff who are going to get the benefit of the housing were selected by lottery and not pre-selected by the hospital. Another way to look at the qualitative factor is to ask whether or not providing the private benefit is an inevitable result of providing the public benefit. There are a lot of revenue rulings and private letter rulings, mainly from the 60s and 70s, that talk about this. One of the classic examples is an organization that provided a conservation restriction on a piece of property, and the abutting landowners benefit from having open space next to their private land. So they benefit from being adjacent to the conserved property, and that's a necessary component of preserving that land. And then there's the other way to look at this from a qualitative perspective is to analyze things like salaries in terms of whether or not the salaries are necessary to accomplish the TEO, tax-exempt organization's exempt purposes. Some quantitative factors with respect to whether the private benefit is substantial is, as I said before, just the raw numbers. If you're spending most of your budget on benefiting private individuals, there's going to be a question raised about whether or not your organization is primarily oriented toward benefiting the public. There are some examples of this. For example, again, in the hospital context, hospitals can provide electronic medical record services to members of the medical staff. And naturally, the individual physicians benefit from getting those services and goods, but it's an incidental benefit because by far the most benefit goes to the patients served by the hospital and the physicians associated with the hospital, because the EMR services allow the provision of more efficient and effective care to that indefinite class of individuals. Okay, the third topic I want to talk about very briefly is excess benefit transactions. And again, as I said before, the excess benefit transaction rules pertain to the private inurement doctrine and go to the question of whether or not the benefit provided to the insider is reasonable. Disqualified persons we've talked about, but it should be noted here that in the private inurement context, it's also family members of a disqualified person who could be swept up by this. And there are very significant excise taxes that can be imposed if a nonprofit organization engages in an excess benefit transaction. For the benefit of disqualified person, it's 25% of the value of the excess benefit. And if that excess benefit transaction is not corrected within a certain period of time, the excise tax is 200% of the excess benefit. For an organization manager that engaged in that transaction, it's 10% of the excess benefit. Um, so the tax rules provide organizations with a process by which they can establish the reasonableness of the transaction or of the compensation. It's very pretty straightforward. There has to be a vote of a disinterested body of people to approve the transaction in advance. That body of decision makers has to use appropriate compensation or comparability data to establish the fair market value of the transaction or compensation, and the group has to contemporaneously document that decision and its basis. So this just emphasizes the importance of not just having, but maintaining a conflict of interest policy and procedures whenever there is a transaction or a compensation arrangement involving insiders. Now, even if a tax-exempt organization engages in an excess benefit transaction and doesn't fix it, um, it it may lose its exempt status, but only in certain circumstances. For example, um, the factors that are going to go into the IRS's decision whether to revoke exempt status will go to the size and scope of the excess benefit transaction in relation to the overall exempt activities of the organization. The question of whether or not the organization engaged in multiple excess benefit transactions, and whether or not the organization has safeguards to correct or to prevent excess benefit transactions, or has corrected past excess benefit transactions. One other issue I wanted to mention, and I'm conscious of the time here, is when a tax-exempt organization rents space to an employee, that is rental income to the organization. And there is a doctrine in tax law regarding unrelated business taxable income. Generally, rental income is excluded from unrelated business taxable income, but only if no services are provided in addition to the lease. For example, food or beverage or maid services, but normal leasehold services such as, providing heat, public area cleaning, and trash collection are okay and uh, don't rebut the exemption of the rental income from UBIT. So that is what I have to say. I'd be happy now to pass it over to my friend Ray.
Thank you, Peter. As Peter mentioned at the outset of our presentation, I'm an employment attorney. I sit in our office in Boston. I really have two components to my practice. The first part is as a counselor. I spend time working with clients, including not-for-profits, on a variety of employment counseling issues, whether it's onboarding employees, separating them from employment, and frankly, all the issues in between, whether it comes to employee discipline or managing leave processes. In addition to that, a large portion of my practice is litigation, conflict between employers and employees using dispute resolution processes, including courts, to resolve those disputes. What we're going to focus on today really are, at least my component of this presentation is really to help you with some issue spotting, to get you to start to think about if you are to start to explore providing housing to your employees, what is the what do you have to worry about? What do you have to think about when it comes to moving from just being an employer to also providing or entering into a housing relationship with your employees? Providing housing can be a really valuable tool for non-for-profits, but it also creates overlapping employment, tax, and other issues that you need to be aware of. I think the key to navigating these issues is clarity. You need some clear agreements between the employer and the employee. You need proper wage and tax treatment as it relates to your employees. And then you also have to ensure that you're still complying with applicable employment laws. In other words, what we don't want to do is solve one problem, that is, how do I retain or encourage employees to come work for me, only to then borrow a problem of not being able to manage those employees properly. You would think that that's not a problem, but it's difficult for organizations to do that without having a housing relationship as well. Again, some of the things we're talking about here, we're just issue spotting. Employment law is highly regulatory and complex. But what I hope that what you'll do is take away from this presentation some things to think about if you're ever going to go down this road of providing employee housing. At the outset, what we want to consider is that there's clear work time and there's clear non-work time. That's frankly, as we all know nowadays, what is work time and non-work time is often blurred because of remote work, because we can work electronically from pretty much anywhere at any time. But it's different when that is that's a time when you have an employee that's doing those things from an apartment complex next door to you or right down the street, where they're living next to colleagues. Perhaps they have a supervisor or two in that same residential complex. You could see where that would present options for people to discuss work outside of, the four walls, if you will, of their normal work life. You could see that as an opportunity for a supervisor or manager to have a conversation about work with their subordinate in the residential complex, in their housing situation. Again, further blurring the lines between what is work and non-work time. That matters, of course, because employees, and in particular, non-exempt employees, so an hourly employee, has to be compensated for all the time in which job-related duties are performed. So if a manager is having conversation with a subordinate in the housing provided by the employer, even if that's outside of the work time, you're running it up to a compliance concern when it comes to, are they properly being paid for all of the time that they work? An easy way to address that is to have a written agreement between the employer and the employee that sets out very clearly what is work time and what is not work time, what type of things can occur off hours, and what cannot. There are disadvantages to entering into employment agreements with employees, especially maybe a lower paid employee or a non-exempt employee. If in those instances we don't want to enter into a formal written agreement, such as a contract, at a minimum, what we would want is some sort of employer-endorsed, formally approved policy setting out what should and should not be done when it comes to interacting with employees when they're not at work. When housing is offered to employees, another issue that you need to be considerate of are, frankly, discrimination issues. Housing is a benefit. If you don't apply an evenly set of criteria to your housing process, that is, who will be eligible for the housing, who gets offered that housing, who's selected, you run the risk that you're of allegations that as an employer, you're treating different groups of people differently. Even if it's not intended to be that way, you run the risk that we have a disparate treatment where Perhaps older employees are being treated differently than younger employees. Maybe you're trying to recruit new talent. So you're offering the housing to a younger set of workers, but that's not being provided to the older set. An easy way to address this from a company perspective is to have a policy where you have a clear set of criteria in place stating how you're going to approach who's offered this type of housing program and who would be selected. For example, all employees in a certain position or working within a certain department are the ones who will be eligible. Maybe it's only new hires after a certain date. Maybe it's only those who work in a specific location, but having some set of objective criteria to look to is really important there. An example might be instructive. Even once you have your housing set up, you've actually started to provide the housing to your employees. You have to be considerate about how you're treating the employees while they're working for you. An example would be a large social services agency provides a set of apartments nearby to their employees to both recruit and retain talent. The organization had a policy in place that said if employees go on FMLA leave, Family Medical Leave Act leave, here in Massachusetts, we also have the paid family medical leave law, so that would be applicable. But that social services agency had a policy that if an employee goes on FMLA, they have to vacate the housing during the time that they're working. That presents problems because in that particular instance, what we were doing is we're treating those employees on FMLA different compared to employees who took other types of leave. And so at least in that instance, the Department of Labor said, that social services agency did it okay because it wasn't just employees on FMLA leave that had to vacate the housing. It was anybody who was on leave. But you can see how those are the types of issues that can result in discrimination. And you just want to have a process in place to address that. Applying your policies as they existed before you also start providing housing is really not sufficient. You have to go back and look at those policies that exist at the time you're adopting the housing to maybe see if you need to modify them to account for the fact that you're entering into these additional types of relationships. When providing housing to employees, the other thing I just really want you to consider is don't forget the nuts and bolts of employment law. Don't forget the basics. Employees have to be compensated for all of the work that they do. These issues sometimes arise when employees are provided, housing because, employers will want to provide, rather than provide them the full set of wages, employers will try to see if there's a way that they can, instead of the full amount of wages, apply a portion or the value of the housing to their wages. In this context, where we're talking about a not-for-profit organization providing housing sort of off-site, near or close by to their employees, I would recommend against trying to change their wages. That is to give a credit against their wages for the value of the housing, mostly because of the reasons we'll talk about in a second. Making sure that you hit all of the criteria to allow for that to happen they're very stringent and they're not likely to occur in most instances here. Housing is really not a substitute for wages. Employees must still be compensated for all the time that they worked. Minimum wage is still $15 an hour, whether or not they're provided that housing or not. In some circumstances, an employer can take a credit, is what the Internal Revenue Service calls it, a credit towards wages of the value of the housing and supply, but the circumstances are very limited. In order to do this, you would have to meet certain criteria. That is that the housing must be provided by the employer. The employee has to voluntarily accept that lodging. It can't be required that they accept it as a condition of their employment. It's furnished in compliance with federal and state law, so that you have to comply with all of your regulatory issues there. It has to be primarily for the benefit of the employee, not the employer. So what they don't want you doing is the employer getting some kind of benefit, financial benefit from providing that housing, and then trying to take a credit against the wages that are owed to the employee for the time that they're working. And then in addition, the employer, and this is a very strict requirement, the employer has to maintain very accurate records of the value that is being attributed to the employee's wages, whether that's maintenance of the property, it's in other operations. Finally, something to consider when addressing housing and employees is whether the value of the housing that you're providing to your employee is taxable or not. That is, whether it's going to be attributable as income to your employee. Peter alluded to some of this in his presentation. Generally speaking, employee housing is considered a taxable fringe benefit, but there are some limited exceptions to that. In order to be excluded from an employee's income, that is to be tax-free, the housing must satisfy all of the three following tests. The first is that it must be furnished on the business premises of the employer. If you look at the regulations that interpret this requirement, what the IRS typically means, what the Treasury Department typically means, is literally where the employer performs its business, not on a separate location. Second, it must be for the convenience of the employer, not for the convenience of the employee. That is, there's going to be some kind of tangible connection between the job functions or duties of that employee and the housing provided to them. In this context, again, what we're talking about is these company towns building a apartment complex next door. That's not likely to trigger that requirement. And then finally, the third requirement is that the employee is required to accept it as a condition of their employment, that it's not an option. And depending on the circumstances, that's not always easy to meet. With that, I'm going to turn it over to my colleague, Kathy Garrahan.
Thank you, Ray, and good morning, everyone. As a little background, I'm a land use and transactional attorney, primarily in Metro West and Central Massachusetts, and represent several nonprofit organizations. As to state and local zoning-related rules, there are only a few special laws or regulations on employee housing, whether specifically allowing or prohibiting employee housing as a use category. We'll address some of the exceptions in a few minutes, but outside of the exceptions, standard zoning, building, health codes will apply to an employee housing project as they would to any housing project. I'll say up front that I have a lot of content and I will try to get through it all. We'll be sharing slides, as you heard earlier, for anyone interested. So if I fly by something, don't worry. Because, Ray, if you could go to the next slide, please. Because I assume that not everyone here has a zoning background, I thought it may be helpful to share some brief information. Local land use restrictions are set by each of Massachusetts' 351 cities and towns under state authority of the Zoning Act, which you may hear referenced as Mass General Law, Chapter 40A. These requirements apply to regulate the use, dimensions, and density of development. Under the Zoning Act, each municipality codifies its priorities and the purposes of its land use regulations. In towns, these are generally called bylaws, and in cities, they're generally called ordinances, and sometimes in each, they're called codes. An example of zoning purposes can be seen in the zoning ordinance of the city of Framingham, which I put on this slide. And you can see Framingham's express purpose is promoting life, health, safety, convenience, and the general welfare. And those are very typical purposes you would see in local regulations. As a nuance, different types of zoning codes are used across the country with some areas applying what is called form-based zoning, which looks at density, shape, and physical form more than it looks at uses. Although some Massachusetts communities are starting to talk about this type of zoning, for the most part of Massachusetts, a district-based model is used, which focuses on the mix of dimensions, use, and desired locations of each in a way that tries to direct the sort of land use and density communities want or don't want in certain locations, and either encourages or discourages growth and change. If you go to the next slide, please, Ray. This slide lays out typical dimensional categories that cities and towns impose, and you can see generally lot area, frontage, setbacks, coverage of land by a building or impervious areas such as parking areas, landscape, height, and parking. If we go to the next slide, please. This slide lays out typical use categories, and you can see generally residential, commercial, industrial, institutional, mixed use, agricultural, and what's called accessory. The housing for employees is generally treated the same way as any residential use, such as single family, multifamily, dormitory, lodging house, sometimes an accessory use. If you go to the next slide, please, Ray. And this slide details where employee housing is mentioned in local codes, which is very infrequent, as I said earlier, with some of the limited places being usually in seasonal areas, such as Cape Cod or the Berkshires. One example is the Yarmouth zoning code, which specifically allows hotels and motels to use a portion of their rooms for seasonal workers. I'll note the state's Affordable Homes Act of 2024, which many of you may have heard of, created the designation of seasonal communities for certain municipalities to encourage addressing housing needs for essential public employees. That would be employees of the city or town or other public employees to be able to take advantage of unused hotel rooms. The one tenuously related category you may have heard of is called workforce housing. And that is a type of housing usually to encourage additional housing for workers who earn up to 130% of the adjusted median income of the area. These are typically not tied to an employer, although they could be. And these would typically require a deed restriction on the property, and they are sometimes tied to a special state funding program for workforce housing. Whether with certain targeted zoning or otherwise allowed because a project happens to fit under local zoning, housing employees from employers and nonprofits tend to be in healthcare, senior living, and education, and often, but not always, for employees with overnight responsibilities. Some examples I'm sure everyone can think of are housing for faculty at colleges and private schools, housing for interns. I know that in Worcester, the American Antiquarian Society has housing for its summer interns. Other places of the country, Cook Medical Center in Indiana created a whole subdivision for hospital workers, which is an example of very large project to benefit nonprofit workers. Some towns and educational institutions provide employee housing to attract workers, as mentioned, usually teachers or sometimes municipal staff. The town of Lexington has a program allowing town and school employees to apply for eligibility in Lexington Housing Authority rental units, as an example. We're aware here at our firm of 3 new projects for private schools for faculty and staff, which have been encouraged because of the challenges in the current housing market. If we go to the next slide, please. Oh, I'm sorry. Could you just go back one briefly? I did want to mention when employee housing is not specifically mentioned in the local regulations, sometimes it can be allowed as an accessory use. This would more be for just a small number. You may have overnight security staff who have an apartment on a campus. Uh, then dormitory is kind of self-evident. And in these days where even dormitories for college students are more akin to apartments or suites, something we might think of as multifamily could actually be classified as a dormitory. Traditional multifamily, the Dover Amendment, which I will go into in more detail, which is for organizations that can qualify as nonprofit educational uses, and that allows some flexibility both for use requirements of a city or town and dimensional requirements. Accessory dwelling units could also be taken advantage of. I don't know of any yet since those laws have loosened in Massachusetts, but say a nonprofit was renting some single-family housing in the community that they make available to their staff, or buying those single-family lots. Additional housing on those lots could be added under accessory dwelling units and benefit employees. The MBTA zoning, which people have heard of as well, has allowed 15 units an acre in certain zones, and that's another opportunity, even though it doesn't specify employee housing as being a beneficiary, certainly could be. If we go to the next slide, please, Ray. The easiest route for employee housing would be buy or lease in a residential zone where the type of housing is already approved. That's kind of self-evident, but that certainly is the easiest. I did make a note here about being subject to landlord-tenant law, and I understand Samantha may be mentioning that, so I'll skip over that. If we could go to the next slide, and this addresses the cases where you cannot plug into existing zoning and opportunities where your project will fit into the local code. In those cases, the relief and approval would be needed from local authorities, whether it's planning boards, zoning boards, city councils, special permits, and those require a supermajority vote. They could be planning board, zoning board, or city council, depending on the local rules. Variances are the highest bar, and a hardship needs to be demonstrated. So that's a steep hill to climb to get a variance for an employee housing project. Zoning changes, which are an extensive process. In cities, they would need to go before the city council, the planning board, and in towns, they would need to go to town meeting. So those are extensive processes. And then the zoning exemption under the Dover Amendment, which I will talk about a little more. If we could go to the next slide. Actually, go back. I think I didn't. Okay. Just to address who qualifies for nonprofit educational exemptions, the user must be must own or lease property and be a nonprofit educational corporation. So the owner of the property could actually be a for-profit, but in that case, there must be a lease with a qualifying nonprofit. And the nonprofit must be authorized to engage in educational activities Um, I'll go in a minute into more detail on what are educational activities. Obviously, schools are pretty much automatically determined to qualify if they are nonprofits, but there are other nonprofit activities that Massachusetts state law has deemed qualified to be considered educational under the Dover Amendment. So if we can go to the next slide, please. And I'm not going to go into this in detail because of our time, but in generally, nonprofits that engage in teaching life skills, therapy and rehabilitation that is related to uh, eventual independence, life skills, learning to function with a disability. There's a large range developed under Massachusetts state case law that give background on what types of programs can qualify. And I've pulled out some examples in this list here, which you could read more about later if you were interested. But what's very important is that the education must be primary or dominant. So it can't just be a secondary focus of the organization and the activity. It must be primary or dominant. Next slide. The Massachusetts case law has looked at what is not educational. And some examples, certainly organizations that are for profit immediately do not qualify. Activities that are really recreational and not educational do not qualify. Often activities that a participant can opt out of and is a red flag if there's a determination being made as to whether the organization qualifies or not. The people going to a school have to attend the school. They can't just sign up and not go, put it that way. So there's case law has set out different tests to determine if a use qualifies or not. One of the leading tests was developed under the Regis College case, which people may remember. A senior living program was proposed to be located on the Regis campus. The court eventually sided with the town and determined that the use was not educational because even though activities were offered to the seniors, which were educational, they weren't a requirement of living there. There was no way to enforce the seniors participating in educational activities. So it was deemed that the education was not the primary or dominant purpose. Really, housing was the purpose. If we could go to the next slide, please. And this goes to reasonable regulation. So this is what a city or town is allowed to require of a Dover Amendment applicant. Cities and towns can regulate, but it has to be reasonable and it can't be a facade to deny a use. So this gives Dover Amendment projects a lot of leeway in terms of the use, the dimensions, height, yard sizes, parking requirements, and this is often where there's negotiation with the cities and towns. It is up to the nonprofit to show why what they're proposing is essential for their use. But the case law does back up the nonprofit if the request is the request shows a project that a city and town can grant without really compromising municipal priorities such as safety, they have to really rise to the level of a very important municipal concern, not protecting property values or not aesthetics, not even off-site traffic. So there is a lot of support for nonprofit educational entities for designing projects that they can show are reasonable and that the town or city can accommodate reasonably. Um, the let's see, next slide, please. Yeah, it's important to note that the Dover Amendment only applies to zoning, not things like sprinkler, fire safety, stormwater regulations, accessibility requirements, conservation requirements, aquifer protection district requirements, earth moving, the environmental there. That's often a misconception that people need to understand that the Dover Amendment helps with zoning, but not non-zoning considerations that a city or town may be concerned about. If we could go to the next slide, please. I wanted to briefly talk about restrictions, that it's important for a nonprofit to consider upfront what they would do if they're no longer going to use, say, a new building that was built for employee housing. Is there another allowed use? And also that the the project could be subject to affordability restrictions. So that's something to explore. That even though it's employee housing, there's still, based on local regulation, there still could be some affordable housing regulations attached to a project, and that should be explored. With that, I'm going to hand off to Samantha McDonald for her presentation.
Thanks, Kathy. I'm Samantha McDonald. I do work with nonprofit organizations, and a lot of landlord tenant law and commercial real estate is the bulk of my practice. So one of the things that we have found, as Peter touched on, is that a lot of nonprofits are finding that a way to give them an edge in hiring is to try to provide housing for their employees. In some cases, this makes a lot of sense. In some cases, it is just about getting the employees, the employee pool that they're looking for. But some of the things that people don't take into account is how does this affect your taxes, which both Ray and Peter have touched on. And are you ready to be a landlord? And I think that is important. I'm going to go, I know we're running very short on time, so I'll be very quick on the tax part. There is a mechanism under state law for charitable organizations to be exempt from local real estate taxes. You have to be a charitable organization. Not all tax exempt organizations are charitable. If you're a Chapter 180 mass corporation, then you and your charitable purposes are scientific, educational, then you have a hope of being tax exempt. You must own the land. You must use the only portions of the property that can be tax exempt are the portions that are used for your charitable purposes. Doesn't matter if it's another organization's charitable purposes. There's a case where a religious organization leased land to a conservation organization, and the conservation land was not tax exempt because it was not the religious organization's primary purpose. You need to file your 3ABC annually along with your Form 990 with the town assessor. And you need to file the 1B3 on acquisition of the property. Thanks, Ray, excuse me, Peter, next. Yeah. So is housing part of your charitable purposes? If you are an organization that is providing housing as part of your charitable purposes, you are a a SMOC or any other kind of organizations where they are the actual purpose is providing housing for an indeterminate group of people, then I think you're safe with it being part of your charitable purposes. However, if you are providing housing as an ancillary thing in order to get your employees, you have to look at whether you are providing housing at a below market rate, which would sort of arguably further your charitable purposes because it allows you to have the employees to do the jobs, or if you are providing it at a market rate. If it's at a market rate, I think we circle back to what Peter was talking about with potential unrelated business income issues. Thank you, Ray. Thank you, Peter. I'm sorry. I don't know why Ray, I think Ray's doing this. And then the big question is, are you ready to be a landlord? It depends on what you're doing. You know, some organizations have a night staff person in a group home for, say, the developmentally disabled. That is clearly part of the job, having that apartment so you're there in case anybody needs you. Other people simply have housing off-site that, you know, and so the question is the nexus between the job and housing as to whether or not the court will see your employee as a tenant or as a licensee that is in that piece of property simply because they are your employee. And what winds up happening is employees quit. When they quit, they typically understand that they're going to have to leave the housing if that nexus is pretty close and you have done your homework in preparing the agreements with the employee, the housing agreements with the employee. If it's an offsite housing that is being provided just to make their lives easier or make your life easier, it gets much more attenuated and it becomes much more difficult to prove to a court that this is related to the job. And therefore, that the employee needs to leave more quickly than they would if they were a tenant and without the tenant protections. The conservative position is always to assume that they are a tenant. And now that it's 12, I will just say security deposits are a recipe for a disaster. Don't do them. I'm happy to talk with anybody about why. And we talked a little bit about what happens when the employee is no longer an employee. The real issue, and this gets, you can see where the nexus is close, where you have a real clear understanding of that person is only living in this place because that is a requirement of the job. They are a caretaker of the property. They are a caretaker of the people within the property. Those are easier, and you can usually remove those people with a 3 to 10 day notice to quit. What do you do between those 3 and 10 days is a real problem, and it's something to be considered. With people who are in housing that is external to the site, to the job site, it gets more difficult. I recommend that you treat it as a tenant and you give them the full 30 days notice, unless they're not paying you, in which case it's a 14-day notice. Peter, next slide. Oh, there we go. We're done. Does anybody have any questions? Claire, is there anything in the question?
We're aware that we're now into the
your lunchtime.
And we know that we've given you several platters overflowing with food for thought. I want to thank my chef de cuisine who've been cooking this meal up for you. You have our contact information, and as said, the slides will be made available to you, so we would be available to help you chew through and digest this material at your leisure, and we'd be happy to speak with you at your convenience. Claire?
Yes, thank you so much to our presenters. And as I said, I will be following up with the slides and recording, as well as the contact information for the presenters. So you can definitely all feel free to reach out with any questions that you have.
Thank you for attending and have a lovely day.
Thank you so much.